Thank you very much. Yes, good morning, Mr. Singer.
Yes, good morning, my lords.
Yes, I'm sorry, it is quite warm in here.
Thank
But
you.
we'll just have to do our best.
Yes.
Before we start, can I say that we've read the papers. We have what we think is a lively appreciation of the issues. Obviously, council can make whatever submissions they want, but we think that we are on top of the differences between you.
I'm very grateful for that indication, and also on behalf of all of us, very grateful for allowing us at least some respite from the heat by not wearing on.
Yeah.
My lord, just for the record, I appear for the appellants with Mr. Ward and Mr. Paul. The respondents are represented by Mr. Richards, King's Counsel, and Ms. Wakeman, and the first interested party is represented by Simon Barker, King's Counsel, as its lay representative with the permission of your lordship.
Yeah.
The second interested party has not taken any part in the proceedings.
Right.
My lord, I was going to inquire as to whether your lordships had had the opportunity to read the skeletons and to acquaint yourselves with the 4 bundles.
Yeah.
You obviously have. My lord, as you know, this is an appeal against a refusal of Mr. Justice Garnham on the 7th of July the last year. It's a renewed oral permission application to grant the appellant permission to bring a judicial review in respect of a decision to grant building safety fund funding to the interested parties on the 26th of August 2022. I might perhaps just read that decision too. I'll ask your lordships to read that decision. I'm sure you already have. It's at page 160 of the core bundle. It certainly has the benefit of brevity.
Because it had all been said before.
Well, we would say no, my lord, but we should perhaps deal with that. It certainly wasn't what it said, is the reason why it was brief. My lord, what it said was, thank you for your letter. The 22nd August, the department has noted the content and will respond substantively shortly. And pausing there was no response substantively or shortly. In the circumstances, the department has decided to enter into grant funding agreements in relation to the development at Hemisphere and Jupiter 2, both in Birmingham, in accordance with the terms of the pledge. The department expects Redrow to reimburse the department for all funds paid out under the terms of the GFA, where these are not reimbursed by the applicant in accordance with the GFA best wishes. So that's the decision, and as you know, one of our grounds of challenge is that the decision did not contain any reasons.
Yeah.
My Lord Justice Coulson granted leave to appeal, and that is at pages 12 and 13 of the core bundle. That, as your lordship knows, was on the basis that the appeal had a real as opposed to a fanciful prospect of success, and that this was one of those rare cases of permission, because the BSF is, I quote, a critically important element of the government-led plan post-Grenfell, and that guidance of funds operation in practice could be of assistance. And your lordship also noted the need for cooperation between the parties in the operation of the building safety fund, and I will have a few things to say about that in due course. My lords, there is a preliminary matter, which is our application notice of the 19th of February to rely on the additional evidence bundle. That application is not opposed. The court will no doubt have noted that one of the key documents, there are 2 key documents, at least in that bundle. One is the deed of bilateral contract between the parties, and the side letter, which disapplies clause 13.8 of the self-remediation terms, which are part of the agreement, until these proceedings are finally determined.
Yeah.
My Lord, the documents which we seek permission to rely upon are referred to by all parties in their respective skeleton arguments,
Yeah.
and in arms. And in view particularly of your lordship's reasons for granting permission and the subject of these proceedings, we respectfully submit that the parties should be permitted to rely on the contents of the additional evidence bundle.
Yes, well, since everybody refers to them, it would be slightly counterproductive not to allow that.
Yes, thank you. Well, thank you, my Lord. My Lord, in a nutshell, our submission today is that both of the grounds of appeal disclose properly arguable grounds of challenge to the decision, and that Mr. Justice Garnham was wrong to refuse to grant permission to apply for judicial review. And I hope it helps if I summarise our submission in about half a dozen paragraphs before going on to make them. And although I'll start with standing, which is still in issue.
Yeah.
The judges below, we say, were correct to decide that the appellants had standing as being potentially effective in the sum of approximately £30 million, as it was. And we say once it is accepted that the appellants have standing, it becomes very difficult to see why, as a matter of principle, an affected party can't challenge the decision. So our headline point on standing is we do have standing, and the judges below were right to say that. As far as delay is concerned, we say that Mr. Justice Eyre's decision, affirmed by Mr. Justice Garnham, was correct, and it's a matter of discretion, and as your lordships of course know, shouldn't be overturned by an appeal court without being obviously wrong, and no such submission has been made out. It's just an attempt to re-argue the delay point. I have some other points to make about delay, but that's the standard point. As far as the so-called overarching point taken up by Mr. Justice Eyre is concerned, we say that the proposition that it's only applicants for building safety fund funding who are bound by the building safety fund guidelines, and by extension are the only people who can bring a judicial review, must be wrong in principle. We say that clearly an applicant would only ever challenge a refusal of a grant, and here, of course, there is a grant which is not being challenged by the applicant. So a grant of funding effectively precludes a judicial review challenge for anyone else affected, if the overarching point is correct, which we say demonstrates, frankly, in and of itself, that it can't be correct. Of we also note that this was not a point that the respondent raised in its summary grounds of resistance. It was a point that Justice Eyre raised, and Justice Garnham picked up on. Lord, as far as ground one is concerned, failure to comply with the guidance, there is the only published document which explains the basis of funding is the guidance, and it is the respondent's own document. So rhetorically we ask, what else would you use to see if the funding was lawful other than the respondent's own guidance? And we also note, although they don't apply because of the side letter to these proceedings, nevertheless the self-remediation terms at 13.18b, which is apparently page 51 of the additional bundle, clearly say that a ground for not reimbursing is that it manifests ineligibility under the rules of the fund. And the only rules of this fund are the gadgets. So
when you say at this point, are there any rules at all?
Well, we say that there are.
Well, I appreciate there's the guidance, but
yes.
are there any
other
rules?
Well, the only rules that can... It might be helpful if I take your lordship very briefly to page 51 of the...
Well, I'm familiar with the term. That's why I was asking whether there were any rules, either capital R or small r, dealing with the BSF guidance, or is it just, dealing with the BSF, or is it just the guidance document of June 2020 updated July 2022?
That's the only document that we know of.
Yeah.
And the only documents that have been referred to by, excuse me, Lord, that have been referred to by all the parties in this matter.
Because it's not separately defined in the DBC.
No.
Okay, so you say, well, these are the only rules, yeah.
And therefore, what else do you use to see if the decision to fund is lawful?
Yeah. And
in this matter, we say that the grant was outside the guidance because of non-compliance with the guidance. And in that regard, we would take you take you in due course, but for now, if you just note, so the paragraphs at the top of page 37 of the supplementary bundle. As far as ground 2 is concerned, which is failure to give reasons in the decision, we say if you engage as a public body in a process leading up to a decision to grant public funds, and you're engaging with a party who is expected to reimburse that grant to you, fairness must dictate that you are obliged to engage properly and in particular to give reasons for your decision. And here, as I've already pointed out, the decision contained no reasons at all. Lord, so those are our sort of headline points. There is also a point we would like to make on cooperation, and bearing in mind that we are still at the pre-stage of getting any actual evidence from the respondent, because we're still at the stage of the court deciding whether we should have permission to bring a full judicial review or not.
But they are bound by the duty of candour even at this stage.
They are.
Yeah.
And in that regard, we wrote at the pre-action protocol stage and asked for documentation in respect of the matter. And my lords, it's page 215 of the supplementary bundle, which is the pre-action protocol reply by the respondent. I won't take you to the request because it repeats. And having accepted that, as the Coulson do, over the page, the previous page of 214, noting that whilst the duty of candour is engaged at the pre-action stage, requests for information and documents should be proportionate and limited to that which is properly necessary for the claimant to understand why the decision has been taken. And then at paragraph 29, in respect to the specific request made, one of those requests was the factors that the defendant then was considered in its decision making, and two, the exact reasons why they've chosen not to engage with the insurer. Please refer to the overview of key reasoning. We don't consider the provision of further information in this regard as proportionate or properly necessary at this stage. And we say that is frankly inappropriate and unhelpful.
Well, it works to your advantage to this extent, doesn't it? That we, on the basis of that reply, can assume that there was no relevant exchange of documents of the sort that in a more formal circumstance you might find as a briefing to a minister and the minister's response.
Yes.
That there is no recommendation document or formal document setting out the reasons.
Well, or if there is, we certainly don't have it for purposes. But I'm
It
more
would
than...
be difficult if it existed. It would be difficult to swear over paragraph 29.
Yes.
Well, Mr. Ordman can probably confirm it.
Yes. Or it does, we do say, that helps us.
Sorry, Mr. Richards.
That helps us for the purposes of today, but it also is somewhat disconcerting, if I can put it in that way, that not a perfectly reasonable request for some further information is just dealt with, frankly, with a blanket stonewalling there. I don't need to say any more about that at this stage. Lord, you are, of course, aware that the respondent has served a respondent's notice, which raises two issues which logically need to be dealt with first.
Yeah.
Standing and delay. I spoke to my learned friends outside, and our submission in any event was going to be that we should make some submissions on those issues first.
Yep.
As part of our overall submissions. And if there are any matters raised by the respondents in their submissions which need to be dealt with in a reply, but then of course subject to Lordship's views, we can do that. Lord, turning now to standing, both the judges below found, we say properly, that the appellants had standing. We also refer in that regard to the matters that were put in the reply before Mr. Justice Eyre, which for your note, I won't take you to it now, but for for your notice, paragraph 43 at page 157 of the core bundle. The relevant legal test is identified in the paragraphs from Smith, which are in the authorities bundle. Paragraphs 2009, which I'm afraid has not been lined, and
2009
and 2010, which are page 334 and 335 of the authorities bundle.
344, 345.
Yes.
Make sure I've
Sorry.
those in line.
I may have given you, I apologise. 334. Sorry, not 334.
Say again?
I'm so sorry, I can't read, not for the first time, I can't read my own handwriting. 334.
334.
So, 2009, which as I say, it is not paragraph, but the test is expressed in terms of interests rather than rights, because what modern public law focuses on are wrongs. That is to say, unlawful acts of public administration, they often, of course, infringe correlative rights, but they don't necessarily do so. Hence the test for standing for public law claims, which is interest-based rather than rights-based. The matter was put with great clarity by Lord Hope. And as the quote, a person may have a sufficient interest to invoke the court's supervisory jurisdiction in the field of public law, even though he can't demonstrate it has a title based on some legal reason to do so. A personal interest need not be shown if the individual is acting in the public interest and can genuinely say that this directly affects the section of the public he seeks to represent. Then it's noted as a similar testing Northern Ireland. And then 2010, the issue of whether a claimant has sufficient interest goes to the court's jurisdiction to entertain the claim.
Yeah.
And the point that my learned friend relies on about the defendant can't merely agree, and the court can take the point even if the parties don't. And assessment of the standing must relate to the circumstances as they exist at the time permission is sought. And my lord, what we say about that obviously is the key question here is whether the appellants have a sufficient interest. Well, the party who is being expected to reimburse £30 million as a result of the decision must, we say, have sufficient interest in that process to be able to challenge it. And as we say, I do have some references to where the £30 million comes from, if your lordships want it for the purposes of your note. It's in the supplemental bundle at page 81.
That's the guesstimated costs at the moment.
It's that, well, yes, and in fact, those costs have gone up. And there is another.
Yeah, but this is judged at the time that permission is
yes, at the time, yes.
granted or refused.
Yes, and slightly more than a guesstimate. I think around about 30 million.
Yeah.
In their summary grounds of resistance, the respondent did challenge standing on the basis that the appellants don't accept liability to repay, and therefore they have no right to challenge the decision to make a grant. That is the point which is repeated in their skeleton argument in the court.
Yeah.
But really, at its simplest, the point raised by the respondent is that a party can only have standing, in fact, they say under the deed, the SRTs, which don't apply in this field by agreement. But if they accept liability to repay, since the challenge is as to liability to repay, that means a party against whom a claim is intimated for repayment of sums can only challenge it if it accepts that decision, which is, of course, nonsensical and circular. Lord, we do need to mention that you may have seen, it's footnote 3 of the Learned Friends Skeleton, page 180, that there was reference to some parallel TCC proceedings in respect of a different decision to this one, a later decision. And in our ongoing duty, not just as candour but to the court, I do need to update the court. There are now parallel TCC private law proceedings in respect of a different decision.
So there are now parallel
TCC
proceedings in respect of
a different decision.
Between who?
Between Redrow PLC only and appealer.
Redrow and?
The respondent.
Oh, right.
In relation to another block.
No, one of the same blocks as this, but a decision to vary funding upwards. And that is a claim which is a private law claim. And
On what basis? On what contractual basis is it reported?
Yeah, on the basis of the deed.
On breach of the deed.
Yes. Right. It's declaratory relief that the variation shouldn't have been made. It doesn't directly relate to it, but just in terms of obviously full disclosure to your lordship, and my learned friends obviously know about it, not least because they're the other party, but I thought it was appropriate to mention that now. Now, my lords, coming back to this case, it may be that the reason why the respondent wants to challenge the standing decision is because once it's acknowledged that the appellants do have standing, because they're potentially affected to the tune of £30 million, then a judgment that, despite having standing and being potentially affected, nevertheless, you can't rely on the guidance and can't challenge a decision for funding, looks to be somewhat difficult to reconcile. My lord, we therefore submit that the judge's decision on standing below should be affirmed.
On standing, can I just ask this? Obviously, Mr. Justice Eyre concluded that there was standing on the papers.
Yeah.
Was this a matter that arose before Mr. Justice Garnham?
No, because it was only us who were called on before Mr. Justice Garnham. The respondent appeared, but as did Mr. Barker, but weren't called on to make any submissions.
Right.
And Mr. Justice Garnham didn't take the matter any
Right.
further.
So this wasn't a matter that I didn't think it was a matter he addressed in his judgment.
No, he didn't. But that said, we criticised the respondent in our skeleton for raising standing, to which the respondent came back and made the point that I've just read from the Smith about, well, parties can't agree to give standing. But of course, by the stage we now are at, the judge has already said that we had standing. So it's definitely a choice on the part of the respondents to challenge standing in your lordship.
Well, whether they made a good or bad choice, no doubt we'll decide.
Simply. Well, for our part, we say that the judge was right, and we do clearly have standing because we are potentially affected.
Yeah.
You're right that it does relate further down the line to the point about the actual reasons for it. Can I just ask this? If you have private law proceedings in relation to whether you're going to be liable to make any payments, why shouldn't it all be dealt with under private law?
Well, there are actually some other judicial review proceedings parallel to the other TCC proceedings in which we've been refused permission on the paper because the judge, it was Mr. Justice Sheldon, said it's a private law matter, it's not a public law matter.
Yeah.
But of course, in this case, my lord, there's a carve-out because this decision was taken before the contract was signed between the parties.
Because this is pledge related.
This is pledge related, not contract related. And then the pledge is not a contract, and that's why it has to. We say it has to be. Now, it may be in other decisions, in relation to other buildings, for example, that it's contract or nothing. It may be, but that's not where we are today.
Thank you.
So, my lords, unless I can insist any further on standing at this stage, that's what I propose to say about that. My lords, as far as delay is concerned, Mr. Justice Eyre was not disposed to find that the claim should be dismissed at the pre-permission stage on the grounds of delay alone. And we say that is a matter of his discretion, which shouldn't be interfered with by the appeal court, unless it can be shown that he made an obviously wrong decision. And we say he clearly did not do that. And furthermore, that the respondent's skeleton argument doesn't identify a proper basis for interfering with the judge's discretion. In any event, the appellants explained the reasons why the proceedings were issued just before the 3-month time limit. They arose, most of the delay arose largely because, as I've just shown you at page 160, the respondent promised a substantive response. It was prudent to wait for it, and when it became clear that it wasn't going to be forthcoming, that's when the process kicked off. And further, we respectfully submit that the issue of delay should be addressed at a full hearing, as it may well be relevant to the disposition of the claim if proved, rather than as to whether the claim should be allowed to proceed as a matter of principle at all.
Well, delay tends to be something one deals with at this stage rather than at the end.
My Lord.
Because the court has to take a view as to whether, in all the circumstances, it's promptly. I mean, you point to the awaiting reasons, and we've read the witness statement of Mr. Parkin, who says that's what he was doing.
Yes.
And then in the overall period, there's also the delay on the part of the respondent.
That's right.
Due to unavoidable constraints on availability during this time.
Yes.
Classic.
Yes, my Lord. So, but really, at this stage, as we are in front of your Lordships on an appeal, which in this case is the respondent's appeal, we say this is an appeal from the matter of discretion. Unless it was obviously wrong, it shouldn't be interfered with.
Why do you say obviously wrong rather than just wrong?
Well,
I mean, we don't want to get into a lot of semantics on that.
Well, my Lord, simply because it's respectfully submit that it's quite a well-known principle that, for example, if this were a case management decision, for example, the Court of Appeal would only get involved if there was some mistake of principle. Whereas this is a similar point to that. A first instance judge having looked at the reasons and said, well, I wouldn't knock the claim out for that reason, it would be, we say, inappropriate unless there was some huge error on the part of the judge to say, well, actually, we would have done so. And in any event, we do wonder what difference it would have made had an earlier challenge come along, because there was very little time between the decision being taken and the funding being utilised, in the sense of the building works starting at one of the two premises. And of course now, of course, whatever delay there was pre-hearings, rather fallen into the annals of history, because now we are in almost the middle of 2024, coming up to almost the second anniversary of the decision, and frankly, a short amount of delay at the beginning of the process may or may not be of any relevance at all, my Lords. So, unless you would have anything further, that's what I'm supposed to say about delay. My Lords, turn to the grounds of appeal. Ground 1, non-compliance with the guidance or failure to take account of prior acceptance of cover by the insurer. And my Lords, both Justice Eyre and Justice Garnham took a preliminary point, which Mr. Justice Eyre describes as an overarching consideration. The Building Safety Fund guidance does not purport to prescribe limits to the respondent's power to provide funding, and that's paragraph 19 of Mr. Justice Garnham's judgment at page 6 of the fund.
I mean, Mr. Singer, by all means, make your submissions on this. I didn't read Mr. Richard's skeleton argument as having this at the forefront of the respondent's case.
Yeah.
I mean, the forefront of his case is if we had to comply with the guidance, we did.
Yeah.
So that may be the more important point.
Yes,
So I mean, I understand what Mr. Justice Eyre said,
Yeah.
and obviously what Mr. Justice Garnham said about it.
yes.
But and so by all means, I'm not seeking to cut off your submissions about this, but I apprehend that the real point under ground 1 is going to be whether the decision was unlawful, because in some way it didn't comply with the guidance.
Yes.
if one assumes that the guidance is of at least some relevance.
Yes. Well, my lord, thank you, and I'll be quicker. I may make, with your lordship's permission, I'll make a couple of points. One of the points I was going to make is, of course, that this is a point which the judge may talk, happy to do that, but it's not a point that Mr. Richards, in fact, took when he was settling the summary grounds of resistance. And as your lordship has already said, and as I was going to say at greater length, it doesn't seem to be the main point of his submissions in his written skeleton argument. So it may well be that this is something which, if my learned friend does want to push it, I could pick up if I need to in reply. But our submission, just so your lordship is clear, your lordships are clear, and I'm sure you are, is that this was a bad point for the learned judges to take. And also it clearly informed, in our respectful submission, their view, such as it was, of the merits of what we had to say. Because once you come to the view that, frankly, this is nothing to do with you, appellants, we respectfully submit, it's quite difficult then to have a proper, objective and independent review of the grounds. Because, frankly, you don't really need to. And you've read Mr. Justice Garnham's judgment, and in our respectful submission, that makes very clear. But also, in our respectful submission, it does, in Mr. Justice Garnham's treatment of how the guidance could or might be applied, is also instructive in a sense, because he does refer to his paragraph 20, that there may well be arguments open to an applicant if the Secretary of State ignores the guidance. But because of the so-called preliminary point, he says that that's not open to a non-applicant.
Yeah, well, but in one sense, that's saying no more than an applicant may have a different ground of complaint against the respondent than a developer in the position of Redrow.
It is, but it's also making a general point, which is part of this overriding point, which, as your lordship's already said, and as my learned friend in due course may or may not confirm, it actually wasn't the respondent's position that when they took the decision they were ignoring the guidance. It's their position that when they took the decision they were acting in accordance with the guidance.
Yeah.
But if it was just my point, which may just be a forensic point, and which your lordship may not think is a terribly good one, but I'll try and make it anyway, which is that once a judge has come to a view that, frankly, this guidance just doesn't matter because it's nothing to do with you, it's quite hard then to see that your argument that the guidance was not complied with has nevertheless been dealt with fully and appreciated for you.
Well, judges are quite used to saying, well, I find against you on that, but if I'm wrong about that,
yes,
I find against you on this.
yes. Well,
I spent years doing that.
no. And then your lordship has already got our point about the remediation terms and clause 13.
Yeah.
The eligibility under the rules of the fund, and your lordship's made your own points about that as well. But my lord,
Yeah, if this was under the deed,
yeah,
and the complaint was you haven't complied with the rules, and the only rules are the guidance, then that would suggest that the guidance was relevant. Yes.
and then this is under the pledge. But
Yeah.
If it's right that the respondent says, well, actually, we did comply with the guidance, and that also must mean that they accept that the guidance was relevant to their decision-making process. Otherwise, why would they bother saying that they complied with it? They could simply say, well, there's nothing we need to comply with at all. We simply make a decision in public interest whether to give monies out or not. But that isn't actually what they say anyway. But my lords, I've probably spent too long on the point that, in any event, I apologise for that. But obviously, the real point here is whether either of our two grounds are arguable enough at this stage to
Well, the
proceed.
first point is non-compliance.
Yes. And my lord, in that regard, could I take you please to the supplemental bundle? First at page 35.
Yeah.
About half, a third of the way down the page, when we assess your full application, we will consider a range of factors including.
Yeah.
And the final factor is the efforts you have made to recover costs.
Yeah.
Well, and then we get to the meat of our case, which is page 37. And the first two paragraphs on page 37, which, my lord, I might be permitted to read to you. I know you've obviously read them. Where the developer who built or refurbished the building, subject to the application, is not funding the fire safety works, and where the responsible entity is unable to do so, then the BSF will cover all reasonable eligible costs to address the life safety fire risks associated with cladding. More information about the developer can be found at. Second paragraph. However, you are required to demonstrate that you have taken all reasonable steps to recover the costs of addressing the life safety fire risk caused by the cladding from those responsible through insurance claims, warranties, legal action, etc. During the application process, we will ask for information regarding such steps and may seek further information to satisfy ourselves of the position. Well, we respectfully stress the first of those two paragraphs because before BSF will cover any costs, it needs to be shown that the developer isn't funding them and that the responsible entity is unable to do so. And our simple point is, here, in respect of Hemisphere, cover had been accepted in April 2022. And in respect of Jupiter, the acceptance of cover was expected to arise, and indeed it has now arisen. And so, as at the date in August 2022, when the decision was taken, certainly in respect of Hemisphere, but we say at least reasonably arguably in respect of Jupiter, it could not be shown that the responsible entity was unable to fund the works.
As at the time of the decision, what was the time frame for payment of insurance proceeds? If all went smoothly? At the time of the decision,
Yes.
what was the time frame for payment of the insurance proceeds?
There wasn't.
Isn't that the problem?
Well,
Because if there isn't a time frame for payment, how can you rely upon the acceptance of liability?
well, the question is whether, under the guidance, whether the responsible entity is unable to pay. We say that the department, the respondent, should have engaged with the insurer once they had accepted cover in April, instead of which they engaged, it appears, with us.
But the department has no basis for engaging with insurers.
Well, maybe not, but of course they did.
Well, how can you complain then?
Well,
Or how can you assert that the department should have?
Well,
sorry to be difficult, but at the moment I don't understand. At the moment, you're placing all your weight on the fact of an acceptance of liability, but you accept at the same time that there's no time frame for payment. And payment, as far as your team were concerned, was an essential prerequisite to them getting involved.
well,
And in that case, you have no time frame for the carrying out of these works by Redrow. Full stop. So where do you go from there?
Well, you mean by, does your lordship mean by Redrow?
Well, Redrow certainly weren't prepared to undertake responsibility for the works, either in terms of funding or doing it themselves.
Yes.
So the only people who can do it are the interested parties.
Yes, with insurance funding.
With insurance.
Yes.
They are not in a position to do it without the proceeds of insurance.
But
They do not have any time frame for the payment of proceeds of insurance. How long, just as a matter of interest, do you say the department should have waited for these proceeds of insurance before saying this isn't good enough with a life-critical safety feature?
Well, my lord, I'm not going to duck that question, but as a preliminary to that, what we say is, as at the 26th of August 2022, that wasn't the time to decide, just make the decision anyway.
Well, they certainly, as at the 22nd of August basis, there was no basis for an expectation or anticipation that the funds would become available in time to fund the works with the start dates that had been set.
No, but there was clearly on the part of the respondent an expectation, an incorrect expectation, that when the funds did become available to the insurer, they would be used in part to reimburse.
But that's the respondent can't rely, because they don't know anything about the proceeds of insurance, whether they will. But they've got an imperative to get the work done.
Well, my lord, I was going to show you some documents from before August where the department do get involved in the question of whether the insurers are going to reimburse or not. I'm going to take you to a document at page 82 and 83 of the.
Okay. So when you do, and the documents that follow that,
I'll then
for my benefit only, would you highlight anything which indicates that the proceeds of insurance might have been ready in time to fund the start dates? Because from where I am provisionally, that's quite important.
I understand. I'll try and deal with that.
May I just ask one question on this? Is responsible entity that you refer to at page 37 defined?
It is defined.
Because you seem to have equated it with the insurance company, which may or may not be
right.
right.
I'm sorry, Muller, that's my fault. It's not the insurance company. The responsible entity is the management company.
Right.
So in this case, the responsible entities are the interested parties.
That's right.
Yeah.
And where do you get a
26.
Thank you, that's very kind.
I'm grateful. Muller, I was going to take you in my submissions in any event to the fact that it's clear in our respectful submission that that insurance claims having been made and recovery from insurance being on the cards was clearly in the mind of the respondents before they took the decision. So at page 82 of the supplementary bundle, on the 8th of June, Mr. Hewlett from the department.
So we're in the supplementary bundle,
Yes,
page
82.
and this is the 8th of June.
Yes, 2022. So this is 2 and a bit months before the decision is taken. It's to
8th of June, supplementary 82, yeah.
and it's to Mr. Keogh, who is a Redrow employee. Hi, Richard. And then if I can take you over the page, Lord, to.
This is the netting off email. Yeah.
So, well, you already has the point.
Well, I've seen that they say that they look to you for the money with any insurance proceeds being netted off.
Yes. Once such proceeds are made available to the department.
Yeah.
Now, it's right, as my Lord Justice Stuart-Smith has already pointed out, that there's no time scale for that in that email. But certainly, the position is that the department are expecting, they appear to be expecting to be able to net off the insurance proceeds from what they describe as Redrow's reimbursement. And Lord, later on in the tale, on the 11th of August, which is page 143.
We are confident that.
Yes.
Yeah.
Oh, Lord, yes. And this is again from Mr. Hewlett to Mr. Keogh and also to Mr. Parkins, who's Redrow's solicitor.
Yeah.
We are confident that the department will be able to recover proceeds from successful warranty claims. And then the words, should the department continue with the BSF grant. So it appears that as at the 11th of August, whether the grant was going to be made or not was still not decided, because
And they have the insurance position in mind.
But there's nothing to indicate that the insurance proceeds are going to be available
well,
for a start date.
no, there isn't, and I accept that. And if I hadn't accepted that already, I apologise. I have. There is nothing to.
And it remains, forgive me if I've misunderstood, but it remains the fact that if insurance proceeds were now to become available, by one route or another, Redrow would benefit because the repayment would be reduced.
Actually, my lord, the position now is, and this is a point that I think my learned friend has averted to in his skeleton argument, and it's a point that those who instruct me averted to in their letter of the 22nd of August, that because funding is now available through the BSF, the insurers are not going to pay because there's nothing to indemnify.
Well, that I was going to say.
Right.
Well,
That may be their declared position, and no doubt others will challenge it.
Design 5 against Kenniston Housing Corporation, 1980 something or other. Housing Association grant. Somebody said, well, you can't have the money because you've got it through Housing Association grant, to which the judge said no. So anyway, I mean, that's the insurance position, and that's what Redrow were concerned about. Redrow were concerned that that was the position the insurers were going to take.
Yes, so that by making the decision to grant the funds, that inevitably meant that the insurers would at least try to disclaim liability on the basis that they only pay.
Well, another way through it would have been Redrow to indemnify the leasehold company, the management company, to do the works and take the subrogated rights. But anyway, those are all arguments down the line. What the department was concerned about was the health and safety of those in the block.
Well,
and what's wrong with that?
Well, obviously, my lord, there is nothing wrong as a matter of principle with a government department being concerned about the health and safety of people who live in the block, and the whole fund was established because it's the building safety fund. But, my lord, that's, with respect, not the question we have to deal with when deciding whether the decision to grant funding on the 22nd of August 2022 was lawfully taken or not.
With respect, I think it is exactly the problem that you have to confront. Because you've got your private reasons why trying to protect Redrow, who are not prepared to undertake the repairs themselves, are not prepared to indemnify. The government, as you accept, has an imperative, which is it cannot leave the cladding on the building. And it's got start dates for works, and it's got to get them funded.
Well, but Lord, I do accept that it's a fair point for the government to take that there's a health and safety risk. I don't accept, with respect, that it's imperative of them, and that somehow trumps anything else.
Okay. How long should they wait?
Well, that comes back to Lordship's point, which is how long should they wait?
Yeah.
We say they ought to have been more, since they were clearly almost banking, if I can use that phrase, on receipt of the insurance money. They could and should very easily have taken more of a lead in dealing with the insurers. And they could at least...
With a view to doing what about the start date?
Well, it could have been pushed back. I mean, we know that one of the start dates was pushed back anyway for entirely for reasons of cost. So, if you say there is a start date for some contracts, and that is, as it were, an absolute line in the sand, and we cannot let that start date not happen. First of all, you might put that in your guidance if that's one of the things that you're concerned about. But it's outside the guidance.
It's not a question of guidance, is it? I mean, the start dates were clear in the correspondence. I mean, there wasn't any mystery about what the proposed start dates were.
Yeah.
That was set out by the department in their correspondence.
Yes, but to say that is effectively the trump card to making a decision, and that it means that you can make a decision even though, strictly in accordance with your guidance, the applicant does not comply with the guidance. We say is going too far.
Well, we're getting on to timing, and quite right, because that's my Lord's question.
Yes.
But can we come back
Yes.
I'm still, and I'm sure it's my fault, I'm still not clear what it is in the guidance you say they didn't comply with. Because as at the 26th of August, I think it's accepted that the interested parties couldn't fund the work themselves because they didn't have the money from the insurers. So what's the bit of the guidance that they haven't complied with?
Well, it's the combination. What we see is how you read paragraphs 1 and 2 together. The first two paragraphs on page 37 of this. Namely, first of all, we say actually they are technically able to fund at that stage because they have the insurance backing. It would have been perfectly. Well, they could have.
I'm sorry, that's impossible. To say they're in a position to fund it because they have insurance backing is impossible unless the funds are going to be available.
Well, but once the insurers say we're paying, and we're paying to the tune of.
Now, once they accept the liability to pay, anybody who's ever had dealings with insurers before, as you have, knows that that is not the end of the debate.
Well, maybe, my lord, but the question here is, first of all, whether they were as at August 26th, unable to fund. We say they were not, because at the very least they had a commitment to fund by the insurer in respect of hemisphere. But also, they were required to demonstrate they'd taken all reasonable steps to recover.
Yes, well, that's the second point.
Yes.
And so, reasonable steps to recover.
Yes.
So, why do you say that? I mean, this you must be saying that the interested parties had not taken all reasonable steps to recover.
Well,
why not?
Well, because we say that reasonable steps to recover through insurance claims also means taking those insurance claims to a stage where the insurer says, frankly, no. If the insurer says yes, then the process is ongoing, and it's clear that and this comes to a timing point as well. The Lord said, well, how long do you have to wait before you press the button if you're the department? But equally well, you do have to wait as the applicant to the time it takes to take steps through, amongst other things, insurance claims. And
through to the Supreme Court? Through to the Supreme Court? Or when?
I mean, we're having a bit of a go at you, but the reason why we're having a bit of a go at you is that I think that none of us have been able to identify a formulation of what it is said you are now saying the interested parties should have done in order to take reasonable steps to recover. Well, in the time frame we're talking.
Well, it's not just the interested parties. Of course, we said that this doesn't just apply to interested parties. It applies to the respondent in the sense that they need to.
But they're not parties to the insurance.
No, but they are parties. It's their document which says when they will and won't pay the applicants out, the interested parties out. But look, we also say this, that once the liability has been accepted by the insurer, surely the onus is on the respondent to tell the expected repayer, namely Redrow, but notwithstanding that it's timescale which is the issue here, and there's no evidence on that at this stage. There's no evidence at all from the department. They're saying, well, we looked at the timescales, we had meetings, we discussed it, and this is why we did it.
Well, as I said, the timescales in evidence in the correspondence,
yeah.
And they set out the dates. So everybody knew the dates they were working to, and everybody knows about long lead-in times for these sorts of contracts.
Yes.
Yes. Matters were coming to a head.
They were hoped to come to a head, although as I've indicated in the case of one of the contracts, they didn't start when it was hoped in any event, because there were price rises, and even with the government funding, there was a request for more funding before the work would start. So the fact that you think that it's important to make a start and that there is a contract start date which somehow must be met, we say respectfully that is not an absolute truth. Just as your lordship or Justice Stuart-Smith says, well, just when an insurer tells you they're going to pay, that's hardly the end of the process. I might respectfully suggest to this court that it's not beyond experience that when a contractor says they're going to start on a particular date and or finish on a particular date, that is not necessarily going to happen either, frankly. And
accept that.
yeah. So our position is this, that if you read the guidance in an objective manner, you come to the position where you have to demonstrate that the responsible entity, namely, in this case, the interested parties, are at the date you make the decision, unable to fund the refurbishment. And we say, because the insurer had agreed in one case and was about to agree in another, they wouldn't. But in any event, you're also required to demonstrate, quite strong words, that you've taken all reasonable steps to recover through insurance claim. And that they were in that process of insurance claims, and in fact, demonstrated, as the department knew, or were in fact banking on, that the insurance claims would be part of the funding, in fact. Well, I'm not sure I can take matters on that part of the ground rather much further, but I don't want to try in any way your Lordship's patience, but you will have seen the letter from those who instruct me of the 22nd of August. It starts at page 175 of the supplement bundle. And
presciently identifies some of the issues we're now grappling with.
Yes. And at page 177, makes 2 points. One is 11.2. If funding is for the remediation work is provided by the Building Safety Fund and or by Redrow pursuant to the pledge, it's almost inevitable the insurer will seek to avoid making a contribution, given that the leaseholders will have suffered no loss related to that remediation work. And then the next point, Redrow of course accepts the insurer claims it's entitled to indemnity from Redrow. Redrow denies that. However, there's no reason why the insurer shouldn't comply with its obligation to fund the remediation work and make a claim against Redrow to cover such costs in due course, if it wishes to do so. Now, this is the letter which is 4 days before the short email decision. And then the solution is you should contact the insurer required to comply with its obligations to undertake.
And I mean, looking at the arguments that are very clearly set out there,
yes.
The department would have said to the insurer, pay. The insurer would have said, well, actually, it's all Redrow's fault and they should pay because of the indemnities and the claims over that they refer to it at paragraph 12. Is that right?
Well, no, with the insurer, one would have thought by August 22, or if not earlier than that, any time post-April 22, the insurer would say, well, we've agreed we're going to pay.
Well, yes, but the insurer is one looks at paragraph 12.
Yes.
Redrow, of course, accepts that the insurer claims that it's entitled to an indemnity from Redrow.
Yes, there are.
So the department engages with the insurer. The insurer says, well, we're not going to pay because actually we've got an indemnity coming from Redrow. Well, how long is all that going to take to sort out at a time when the building is not being repaired?
Well, my Lord, if the department had taken that into account in the 3 days after it received the farmer's letter before it made its decision, that might have been a point for them.
Yeah.
Whether they did or didn't, they certainly haven't told us.
Well, no, we understand your reasons point.
Yeah.
But the point here is that even if you're saying they should have discussed this with the insurers,
yes.
If they'd have discussed it with the insurers, given them the information that's set out in this very helpful letter, it's perfectly apparent that nothing's going to happen.
Well, that's not necessarily right either with respect, because certainly in respect of the Hemisphere building, the cover had been accepted in April 2022. And that's for your notice at page 63 of the...
And they've now accepted cover in the other. It's just the insurers then claim that they're entitled to have it all back from Redrow.
Well, they now also claim that they don't have to pay it at all.
I understand that point, yeah.
But at the time, they were saying they could get it all back from Redrow.
They were.
Because that's the letter of the 12th of August at page 157.
Oh, yes.
Yes.
But
if Lord Denning was right to say that cash flow is the lifeblood of the construction industry, the correspondence with Waitmans is a rather gloomy prognostication for getting the money.
well,
I mean, we're focusing on the interested party because of your argument that says, well, the interested party can't afford it. Well, they couldn't afford it unless the insurers paid. And so that's therefore
when there's an ongoing...
the issue, and it remains ongoing. There is now the additional point where they say, well, they don't have to pay because the BSF have paid.
Please excuse me. Well, yes, it's right that there was in the background a dispute between the insurer and Redrow, but at the same time, as between the insurer and the interested parties, there was no dispute in respect of cover on Hemisphere. And there was very unlikely to be a dispute, and we now know there wasn't a dispute, in respect of cover on Jupiter. And the only time that there was a cover dispute was when the insurer did exactly what McFarlane's helpful letter told the government that the insurer was going to do, and said, well, now you're paying, we're not. And of course, in the same vein, if they're not paying, then they won't need an indemnity from Redrow because they're not paying. So,
can I just put this point to you simply so, because none of these are all important insurance points, is that the insurers were quite determined not to pay until they'd been paid. Redrow was quite determined that it wasn't liable to pay the insurers. This was all going to get sorted out, but it wasn't going to get sorted out quickly.
well, with all due respect, vis-a-vis the insured, the insurer was not saying, we are accepting cover, but we're not paying you because we want to get it back from Redrow.
But they'd made no offers in terms of funding.
So we're in April, and by the end of August, the department is then making their decision to pay. And within that time frame, as between the insurer and the interested party, they're not saying, by the way, we're not making any offers to pay X, or we're not writing you a cheque now because we're in a dispute with Redrow. And we also know that at that time, almost at the very time, the department are expecting to get the money back from the insurers.
So Redrow is party to the pledge.
Yes.
Redrow is not itself prepared to carry out the remedial works.
No.
Redrow is not itself prepared to fund the interested parties to carry out the remedial works, which, if they had done, would have probably squashed the argument about the insurers saying no loss, because they could have done it simply by a loan agreement or whatever. So Redrow was not prepared to, I'm not going to put this in tendentious terms, but was not prepared to fulfil the terms of the pledge by doing the work itself. But that has certain adverse consequences because an insurance policy to which it may not be party may not respond to their satisfaction.
Redrow has made it clear in these proceedings, and I'll make it clear again, that Redrow is, of course, committed to complying. Redrow is committed to complying with its obligations under the pledge. It's not a part of political broadcast.
It's just not committed to carrying out the works or funding them.
In this case, because there was insurance cover, and the pledge makes it clear that you don't have to, and the guidance makes it clear that you don't have to pay if there is insurance.
So we come back to the crunch point is your assertion that there was insurance.
Yeah. Yes, and in that regard, can I refer your Lordship to page 157 of the proposal, which is
The letter of the 12th.
yes,
Yeah.
and to the paragraph immediately above, summary of claims against Redrow. coverage under the policy has been accepted by EWIC, and
Yeah.
consequently EWIC has an obligation to indemnify
Yeah.
for the reasonable cost of undertaking. It does not there say, and we're not going to do that because you need to pay us first.
So, but then there are about 8 pages of doubtless contentious stuff
Yes.
In relation to the position,
Yes.
both in relation to building liability orders, remediation contribution orders,
Yes.
the next steps to be
Yes.
taken, and so on.
Well, yes, but again, in the next page, page 158, the second paragraph, now that the claim has been accepted.
No, but it's the first page. It's the first paragraph that's the snooker.
Yes. Well, no.
It is.
Well, no. They say if you won't carry them out, that you have a contractual right to claim an indemnity. But they're not saying, and we're not going to pay out until you do.
Can I just ask this question? This is 12th of August,
Yeah.
And in fact, therefore, pretty close to the decision about which
Yes.
you complain. And it's obvious that Redrow are writing to the insurers, and if I can put it like this, notwithstanding the excellence of the legal arguments deployed against the insurers, getting nowhere. Why do you think the department would have got anywhere when those instructing you got nowhere?
Well, because the department is a government department, and Redrow is not. Because
Do you think insurers just always give in to government departments?
Mum, I would never say that they always give it to government departments. What I would respectfully suggest is where there is a government department who is saying in its own correspondence we are expecting to get money back from the insurer, they may have a stronger man than the insurer in Redrow, where what's being said to Redrow by the insurer is we expect getting our money back from you.
Was it a solvent administration?
I'm sorry, Mum.
I'm sorry. I've cut across you. Was it a solvent administration?
So ultimately, the any funds will be paid by.
We slightly glossed over the fact that at all material times this was an insurer who was in administration.
And the financial services.
Then there may be
Compensation scheme
policyholders'
are-
protection, but
Yes.
it pushes the prospect of receipts of money further and further into the long grass.
Well,
That's my concern.
I understand. Of course, I understand and appreciate the Lordship's concern. And I've already indicated that we cannot say when the insurers would or should have paid as at the 26th of August. But equally well, what we do say, and I'm sorry for continually saying this, it's like a broken record, is that as at that date, it was at least arguable to say that the applicants did not need to call on the BSF and that the department, as the keepers of the purse, didn't need to make the decision, or shouldn't have made the decision, as at that date, to fund because of the status and acceptance of cover of the insurance claim. That's our point, my lord, on that. And
All right, is there anything else on ground 1?
well, just this, and if I may, it's just that obviously the judge below were concerned, as your lordships are, with the question of timing or speed. But in that respect, we say that there isn't anything in the guidance which makes it clear that speed, as it were, trumps all. And at the point which I may have already made, just in case it either wasn't made or it's been lost in the wash somehow, is that the whole process of being obliged to make reasonable requests of others and reasonable attempts to recover from others is itself inconsistent with speed. If this was a scheme which was supposed to operate literally quickly, almost if I might, with some temerity, suggest a sort of be paid now, argue later type of scheme, it would have been very easy to say that, but it doesn't say that.
Well, the word quickly is
Yes,
in the guidance
it is, but it's
as being one of the objectives.
but it's
So
inconsistent.
quick speed is, it might be thought, baked into the BSF.
Except it's inconsistent with having to take reasonable steps to recover from others.
Well, I don't necessarily think that's right. You can have a process that has to be quick, and you can have a process whereby you take all reasonable steps to recover from others, and then it's a question of balancing the two.
Yes.
But quick is definitely part of the objectives.
My lord, yes, but
I think it says to ensure that.
But my lord, that's our point. It's a balance. It's not a trump.
No, sorry, I was just picking you up. You said if it was said that the scheme operates quickly, then it would say that, and I'm pointing out it does. It doesn't say it's a trump, because obviously there are a number of other considerations. But speed is clearly something. It's clearly a factor that the decision maker has to bear in mind.
Yeah, it is. But it's one of the factors in the guidance, and there are others. And if you take one of the factors and ignore one of the others, we say that is arguably an unlawful way to behave. It might be reasonable, but we're not claiming that this was an irrational or unreasonable decision before your lordships. We are strongly suggesting that this is an unlawful decision, and that requires you to comply with the guidance, not to take reasonable steps to do something reasonable. And I won't, unless your lordships wish me to do so, take you to the authorities which both parties have referred to on the need for government departments to comply with their own policy. You may be at my own and have some points to make about that if needed, but I'll reply if I need to on those. I'm taking it rather as read that your lordships have the authorities in mind. So that takes me, apologise, perhaps slightly longer in the day than I've anticipated, to ground two.
No, we've been asking you questions, so don't worry about it. Yeah.
And that is the failure to identify reasons for the decision and or rejecting the contents of the letter of the 22nd of August, and failing to give any adequate opportunity to participate in the ultimate decision-making process.
Yeah. And there are two separate points, or at least I read that as making two separate points. Yes. One is the reasons, yes. One is the cooperation.
Yes. Thank you. That's how it was grateful, because that's how it was intended to be read. And Lord, I just referred briefly to our skeleton, paragraph 23, which is that whether the respondent took the appellant's position properly into account is clearly intensely case sensitive and requires a consideration of the evidence. Page 23 of 22 and 23 of the core bundle. As to how the respondent reached the decision and the matters, if any, that were taken into account. And as Lord Justice Stuart-Smith noted earlier this morning, that, as we say, there's been no evidence at all about that. But one might draw from that there isn't actually anything where a reasoned meeting was held and a decision was taken based on the factors that were considered. Well, it's quite we say this is quite a stark case in many ways, that a party sends a letter from its solicitors, and literally 3 and a bit days later gets a 4-line response that says, "Thanks for your letter, we know the contents, we're going to do it anyway." And longer letter to follow as the story goes. And that's a very unusual situation. So on its face, this decision just has no reasons at all.
But you would accept, I assume, that we have to consider the decision in the light of all of the correspondence.
Well, we obviously can look at what was said before if what was said before is ultimately part of the reasons for the decision. But in my respect,
well, it sets it doesn't have to be part of the reason. Well, it doesn't give the context.
gives a context, but it's still.
I mean, it would be a nonsense to just simply look at the letter on its own, because there would then be absolutely no context. I mean, there'd been a lot of detailed correspondence back and forth. In your favour, it might be said, the respondent was treating you as a party with standing.
Well, there was clearly...
And whilst I appreciate that may go to the question of cooperation and collaboration, which you'll come on to, as to the reasons, speaking personally, I'd take quite a lot of persuading that we simply have to look at the letter in isolation without all of the lead-up.
Well, it depends what purpose you are looking at that letter, that decision for. In my respectful submission, as a matter of public law, if you are in a position where you are a party who is entitled to receive reasons for a decision, then we say as a matter of public law, those reasons should be in the decision, and they are not.
Okay.
The authority which says reasons need to be sufficient for the person to understand the nature of the decision.
Yes.
Who said that? Lord Denning?
It's one of the. I think it was Lord.
Anyway, it's there somewhere.
Garnham. Was it Lord Garnham?
Anyway, whoever it was, someone will no doubt have it. That's the touchstone, isn't it? And don't you have to say that on the material you didn't understand couldn't reasonably understand why they'd made the decision they had?
Well, I think there are two, with respect, Lord, I think there are two distinct questions.
Possibly.
The first is whether there were any reasons. Well, the first logically precedent question, of course, is whether we are a person who are entitled to receive reasons for the decision at all. And the respondent now says, although they didn't at the time, now says, we're not obliged to give you any reasons. We're not obliged to give you any reasons.
All right, we'll assume that you're entitled to reasons.
So, if one assumes that we are entitled to reasons, taking my Lord Justice Coulson's assumption and working with it, then the question is where you ought to find those reasons and what they need to say. And in my respectful position, there are 2 points. The first is, are you you are a person entitled to receive a decision with reasons. Question 1, are there any reasons at all in the decision? Question 2, if there are reasons in the decision, are they adequate? We say, in this case, you don't get to question 2 because the answer to question 1 is no, there are no reasons in the decision. And you see from the decision itself that further reasons were effectively promised. Longer letter to follow. And longer letter did not follow. And the only reasons that my learned friends can now point to are what was said in the pre-action protocol reply, which, first of all, are not the reasons of the department. They're the reasons that the lawyers representing them have put forward in a pre-action protocol.
Well, just on that, I mean, normally the courts will, if we're going to quash a decision for failure to give reasons, we'll tell them to go away and give reasons.
Yes.
Which are normally drafted by lawyers. Yes, we all understand that.
Yes.
So I do think you'll need to engage with the pre-action response a bit more than just saying it was drafted by lawyers.
Well, yeah, but it's also, those reasons were generic and it did not engage at all with the points which McFarlane's made in their letter.
Thank you.
Apart from a very passing reference to insurance, which I'll look at in due course. So we say, I was going to take the Lordships through the correspondence between the parties showing that there had been a great deal of engagement, but perhaps in the interest of speed and the fact that you've got the points, I don't need to do that, other than note the page references in the bundle, some of which we've already seen at the supplementary bundle, page 77, 89, 143, and in the reply at page 241. I won't take you to them because you're
77, 89, 143 and 241.
Yes.
Thank you.
And those are single pages in slightly longer documents.
Or they're the start of a letter where there is discussion between the parties. So, once there is participation in the decision-making process, we say there is therefore a right to receive reasons for the decision when it's against you, and there aren't. But it may, and we say that in a decision which is potentially going to cost £30 million, fairness dictates that you are A, entitled to be in the process at all, and B, that your observations on the process, your objections to the decision being taken, are taken into account properly. Otherwise, the process is itself illusory. And that may go to the question of whether we are entitled to reasons, which I could assume.
Your objection was get the money from the insurers.
Yeah.
They knew that, because they corresponded with you on that very topic.
So, my lord,
because they said they were confident
so my lord,
that they would recover it.
Then, should the grant go ahead? So they had
That goes back to ground one. We're just on reasons now.
Yes.
As you say, you need to have your objections taken into account. Your objection was the insurers have accepted liability, get the money from them. They knew that. They knew that that was your objection.
And the other objection was,
And they had addressed it to the extent that it was an objection. They had addressed that in the correspondence.
and the other objection was, if you don't get the money back from the insurers, but you fund this yourselves, the insurers will suddenly decide they're not going to pay. And they didn't address that. And indeed,
And the problem with that is back to the Supreme Court point. The exhaustion. And that's back to ground one. But just on the practicalities of the reasons, that was your objection. Had they not addressed that in the correspondence?
Well, my lord, we say they hadn't, and they certainly don't. They certainly didn't address it on the 26th of August or after, reasonably shortly after that. And we say they hadn't addressed it in the correspondence.
Okay. Okay, so
Yes.
so on reasons, you say you don't get into adequacy if you're just looking at the letter of the 26th because you say there's nothing.
Yes.
Okay, I understand that.
And in that respect, can I respectfully refer to the Smith at paragraph 9/146, which is at page 359 of the authorities bundle.
359, did you say?
359.
Yes.
359,
Yes.
paragraph 9/146.
Yes.
The rationality of the reasons given.
Where reasons are required, either by statute or by the growing common law requirements, or where they are provided, even though not strictly required, those reasons must be made adequate and intelligible. They must, therefore, both rationally relate to the evidence in the case and be comprehensible in themselves. And at 5, and there's a footnote 549, and in that footnote there's a quote from Lord Justice Wolfe, as he then was. The reasons must be ones which are understandable to those who will receive those reasons.
It's getting close to what I was thinking.
Well,
That'll do. That will do. Well, it wasn't Lord Denning, it wasn't my Lord Justice Coulson, it was Lord Wolfe.
Lord Wolfe, as he then hasn't. Yes, my lord. But the point.
Okay, so, yeah, got that.
And, Mills, we also say that this isn't a case where a decision is taken without any prior debate or discussion. And at no time did, until these proceedings, did the respondent say we're not under a duty to give you any reasons and you've got no right to engage in it?
So the two sort of pressure points, or where the rub is on ground two. One is, did the respondent, in the course of the correspondence, make clear its position and its attitude to your case, so that when it came to the crunch, it just had to say, well, we've taken your last letter into account, but we're still doing it. Is that sufficient? And the second crunch point is, to what extent, if any, can they rely upon what's in the response letter? And that's what we have to do. Those two things are what we have to decide on ground two. More or less.
More or less.
Good enough for Tuesday morning.
Sorry?
So that's sufficient for that.
Yes, but I would like to take you to the contents of the reply, the pre-action protocol reply, because at paragraph 25, page 214 of the supplemental bundle.
Supplemental bundle page
214, my lord. Without prejudice to the position that the reasons aren't required, the ILUC wishes to assist the proposed claimants in understanding the reasons for the decision and the lack of merit, to provide further details of the reasons why it made the decision. One, it was taken to meet the objectives of the fund, and in particular to address historic life safety fire risks with cladding as quickly as possible to ensure residents are safe. Two, the ILUC considered that works would be able to start on the planned commencement dates unless funding was available from either the fund or Redrow, because sufficient funding was not available at that stage from the warranties, which would allow the developments to meet their anticipated start dates, even if such funding might become available at a later point in time. Three, considered it provided Redrow with a fair and reasonable opportunity to take over. However, as was confirmed in the August letter, Redrow was unwilling to do that, and as such was taken to ensure the work could be started and completed as quickly as possible, which is the same as the other reasons. So we say that these are all frankly, not reasons, they're generic ex post facto rationalisations, and with no evidential basis, in the sense that we don't have anything from DLUC saying this is why we said. Now, of course, the lawyers wouldn't have written this unless those were their instructions. Of course they would. But if one looks for contemporaneous evidential support for these points which are being made months later, one doesn't find them, because there may be some contemporaneous support which may be forthcoming if this matter proceeds to a full judicial review, because then you get some evidence from the department, hopefully. But
is there anything? Sorry to ask you yet one more question. Is there anything in the correspondence that you would point to that you say is inconsistent with this statement? I know you will say it doesn't positively evidence it, but is there anything inconsistent?
Not. There's nothing that says the opposite to things
or contradict.
No, that's correct. But, as your lordship's already said kindly, our point is somewhat the opposite of that. And my lord, unless that brings me on to cooperation.
yes.
Which, I mean, we say that there is a stark lack of real cooperation between the department and the developer. It's all, we are going to do this and you will be paying us back. Confirm or else. There's no real engagement on, we say, on the points that were made on the 22nd of August. And we respectfully submit that in making a public law decision, which is the only type of decision this could be, because there's no contract in place between the applicants and the Building Safety Fund, so far as we know, a government department needs to act transparently and fairly, and does need to engage with stakeholders, if I can use that awful word, in which it's called. And here there is a stark lack of that. And we say it's at least possible that had there been more cooperation, that this situation may not have arisen, or may not have arisen, at least in this way. Now the answer to that might be, well, very straightforward, perfectly straightforward. All you need to do, Redrow, is just pay for it. And then you can avoid any of this nastiness. But it must respectfully be at least appropriate for a commercial organisation who has duties to its shareholders to make points which it regards as properly arguable before it simply writes a cheque for £30 million to another party. And the consequences of not engaging may be seen in these proceedings. And I've already made the point to my lords earlier about the response at page 215 to the request for perfectly proper request to ask for the factors considered in decision making. And you've seen those factors now. They're the ones I've just read out in page 214, apparently, and there are others. Well, where in those pages does it say we took account of what McFarlane said about problems that this would cause with the insurance provision?
Well, that's in the actual decision letter, isn't it?
Well,
so we've taken all, I can't remember the exact words, but...
Well, the way that I'll take, if I may, well, it's page 160.
Have I got this right? Your lack of real cooperation submission goes to the position from the McFarlane's letter onwards.
Well, in fact, not just from there. There should have been more cooperation vis-à-vis the interplay with the insurer from April.
But I'm struggling with that. The correspondence, which I had not seen obviously until this hearing, the correspondence seems to me, certainly up to the McFarlane's letter, seems to me, as I put to you, evidence of the respondent treating the appellant as a party withstanding and taking into account their views on a wide variety of things.
Yes, well, I do accept.
And so certainly speaking for myself, I would really struggle to conclude that there hadn't been cooperation then.
But my lord, it's clear that as at the 11th of August, for example, I took to the correspondence, the decision hadn't been taken to branch fund these two developments.
No. I mean, cutting through it, the decision was clearly coming along, and everybody realised that because your clients instructed McFarlane's.
Well, and that's, if we just take it from that stage.
So from that stage, I have your submission,
Yes.
I understand it.
Okay.
But up to that stage, it seems to me that contrary, I think, to the impression I had wrongly formed earlier, it seems to me there was cooperation, and there was, a transparency, an exchange of information both ways.
I'm not going to try and take that.
So the point is focused, which I completely understand, on the McFarlane's letter and the fact that the decision, as you put it, came 4 days later.
Yes, and my lord, I've looked again at page 160 and I can't see any reference there to insurance. Well, my lord, unless I can assist any further.
What would the remedy be? If we agreed that insufficient or no reasons were given, what would the remedy be?
Well, to quash the decision and ask.
And what's the practical effect of that?
Well, on Redrow, the practical effect on that is that they can't ask Redrow to reimburse if the first decision has been quashed. The effect on the...
So we have to quash, the idea is we would set aside the by the department to fund for lack of their giving.
After a full hearing, not today.
Right?
Not today, of course. Today is just a question of whether we should have permission to
Yeah.
proceed to a full judicial review. So one would have to.
Yeah, but I'm just trying to work out what the end game is. The end game is you want a judge to say they gave inadequate reasons or no reasons at all. Therefore, the decision by the respondent to make the grant to the independent party, interested party, is set aside. So, how much of that money has been spent? And
Well, Lord, we don't.
where do we go from there? Because surely all that's going to happen is the department will retake the decision and make it bulletproof.
Well, maybe, my Lord. But
Right.
maybe they will. But maybe they'll think about it and also be given more reasons. But
I'm much more inclined to pursue a route which could have a positive practical outcome than one that couldn't.
well, Lord, in one sense, there's no suggestion that even if that happens, that would somehow stop the remedial works from going ahead. It wouldn't stop.
Some of them are finished. One of them's finished. Not finished, but in progress.
Yes.
Yeah. Right. But so a lot of money has been spent already.
Yes. But then it's just. But
so with the court's discretionary powers.
Well, it's that Redrow seeks to challenge the lawfulness of the decision and the lack of reasons. If either of those succeed after a full hearing, that at the very least means there needs to be a full decision, a further decision taken, with and that further decision comes with proper reasons.
Mr. Richards had better go back to the department and say, retake this decision tomorrow and make it bulletproof.
Well, it may be that taking that decision tomorrow also involves taking a decision with the benefit of what's happened in the last.
Today? Yes, well, I accept that.
Yes.
Okay. But anyway, that's your end game. You want this decision quashed, whether or not it's going to do you any good in the long run.
Well, if it's quashed on ground one, it may do me
Yeah, but that's
considerably more good than on ground two. But even on ground two, it's still a remedy that.
quashed on ground one. We're in a state of complete chassis because this money's been paid. They have no ability to repay it.
Well, there is a remedy, public law.
Redrow walks away from the pledge.
No, Redrow still respectfully submits that it is complying with its obligations under the pledge, which is to pay for those developments which it is obliged to pay for, not those where there are alternative funding.
And the insurer is now in insolvent administration. This looks like an unappetizing prospect, if I can put it that way.
Well, it's unappetizing all round. It's unappetizing to a corporation who. Oh, Lord, the fact is that there is a remedy. Courts routinely give quash, not routinely, but quite often quash decisions taken by government departments for lack of reasons. This is one of those cases.
I accept that. All right.
Unless I'm going to.
Thank you very much, Mr. Singer. Yes.
My Lords, I intend to make my submissions in three parts. First, to address your Lordships on the BSF guidance and the appellant's construction argument. Secondly, to deal with the developer pledge and contract, and in that connection with the question of standing raised by our respondent's notice. And thirdly, to deal with the fairness of the decision by reference to the process of engagement which preceded it.
Yeah.
My learned junior, Miss Wakeman, will deal with our second respondent's notice point, which is delay.
Right.
To turn then to the guidance, which is at page 22 of the supplementary Parliament law.
Yeah.
The nature of this document is clear from its title, and I hope may be forgiven for labouring that this is fund application guidance for buildings registered in 2020.
Yeah.
That there are two aspects to that. First, the Building Safety Fund was established, and these two buildings were registered with the fund in 2020. Registration closed on the 31st of July 2020, as your lordships will see on page 26. So the Building Safety Fund predates and is independent from the developer pledge, which came in April 2022, nearly 2 years later.
Yeah.
And secondly, of course, this is guidance for applicants.
Yeah.
That the second person, you, that we see repeatedly in the guidance, is the applicant for funding. And what the document does is to explain for applicants the purpose and scope of the fund and how to apply. So to pick up on those points, the purpose of the fund is explained on page 27 under the heading Fund Objectives.
Yeah.
The first objective, as your lordships know, is that the historical life safety fire risks associated with cladding on high-rise residential buildings is addressed quickly and proportionately so that residents in those homes are safe.
Yeah.
The emphasis on the need for speed is repeated on page 30 under the heading Driving the Pace of Remediation and Enforcement.
Yeah.
It's obviously key to the rationale for the fund that leaving remediation of unsafe cladding to developers or to insurance companies or to management companies to sort out will not achieve the necessary result quickly enough. In relation to scope, what the fund will and will not fund is set out on pages 31 and 32. And I just wanted to pick up one point on page 32 at the top of the page. This is the final bullet point of an example of what will be funded. Legal costs incurred in connection with a successful cost recovery action. And there's a footnote 9. The GFA, the grant funding agreement, requires applicants to take reasonable steps where it is possible to do so to recover remediation costs from a prior building owner, developer, or cladding installer. And I emphasise that just to show that the applicant's cost recovery obligation continues in the GFA. It's baked in. And then on process, the relevant part of the guidance begins at page 33. The passage on cost recovery is on page 36 and 37. And that brings me to my own friend's construction point, to which the short answer is that the guidance simply doesn't say that it is a precondition that funds are not available from any other source, or that efforts to recover costs must have run their course. It's not what it says. It's not what it says, and it wouldn't make sense, because such a rule would be inconsistent with the fund's emphasis on the importance of driving the pace of remediation. Indeed, the paragraphs on page 37 show the contrary intention. Those beginning where you do successfully recover damages relating to the remediation of the risks posed by cladding, the government will require responsible entities, those are the applicants, to pay the applicants for funding, to pay the government any amounts recovered. In the next paragraph, we will not seek to recoup amounts recovered in litigation which do not relate to the remediation. So that's describing what will happen in the future, clearly envisaging that the process of cost recovery will continue. And for those reasons, with respect to my learned friends, the appellant's construction argument of their first ground of appeal is hopeless.
Well, I think Mr. Singer would say that those contemplate contested actions. What you had was an admission of liability from the insurers, and that's why it's different. Whether he's right or wrong is a different point, but that you're not meeting that argument.
Well, that's an argument as to whether it was irrational for the department to conclude that the requirements were satisfied, that the applicant...
Well, I wouldn't get into that because he says he doesn't know what you concluded because you didn't answer his letter. So I think I'd deal with it on the policy.
Well, on the policy front, I mean, it's very simple. An applicant has taken all reasonable steps to recover the costs from an insurer if it has made an insurance claim under an available insurance policy. But my learned friend, to succeed, needs to go further and say, you must have pursued the insurance claim to the very end and discovered what the outcome is before you can qualify for funding. And that's the argument I have to meet, and it's an argument which I respectfully submit is plainly wrong.
Thank you.
The question whether this guidance limits the department's power to award funding does not arise in our case, in my submission, because, as your lordships know, we say that there was no departure from the guidance.
Yeah, I was going to say, so the case that I'd understood from you, from your submissions, your skeleton, that I put to Mr. Singer is right, that it's all a bit of a red herring, this question of whether it applies or not, because you say, look at the guidance, we've complied with it. And that's the issue for us to decide.
As we say in paragraph 40 of our skeleton argument, my lord, Mr. Justice Garnham's distinction between strict vires and challenge on ordinary public law grounds was sound, but ultimately immaterial in this case.
Yeah.
So that was my first head of submissions.
Okay, so that you say on the construction of the guidance, there was no departure from it.
None.
You complied
None.
with the guidance, and you've referred to those other paragraphs and that footnote on page 32. Yeah, okay, I have that. Thank you very much.
My next topic is the pledge, the contract, and standing.
Yes.
The pledge, perhaps I can show your lordships in the supplementary bundle at page 57.
Yes.
It is a pledge made on the basis of agreed principles that your lordships see in bold towards the bottom of page 57. And they are scheduled to the letter. Page 59.
Yeah.
They're agreed principles, but subject to contract.
Yeah.
And your lordship see in the second paragraph under that heading, DLUHC and each participant developer intend to enter into legally binding full form documentation in the coming months. That contract was indeed concluded on the 13th of March 2023.
Yes.
It's at page 4 of the additional bundle.
Yeah.
Before I address your lordships on the contract, I should quickly show you the side letter, which is on page 2 in the preceding tab, if your lordships have tab.
Yeah.
The key points here are in the fourth substantive paragraph. The Redrow developer remediation contract and this side letter are being entered into entirely without prejudice to the parties' respective positions in the proceedings. And the sixth, this side letter records the agreement between Redrow and DLUHC that clause 13.8 of the self-remediation terms, as incorporated into the contract, shall not apply in relation to the properties, as at Jupiter 2 and Hemisphere, pending the conclusion of the proceedings, whether by full and final determination of the court, including any appeals, settlement, withdrawal, or otherwise. So the contract only binds in relation to Jupiter 2 and Hemisphere once these proceedings are finally determined. Back to the contract, the crucial clause, and I anticipate that your lordships may have this already, of the deed is on page 7, clause 2, by which Redrow and DLUHC agree to comply with the self-remediation terms. I don't propose to address you in any detail on the scheme of the self-remediation terms.
No, because that's all governing the position if Redrow are doing the work.
That's right.
Yeah.
Well, not only that, my lord, because they govern the position in relation to reimbursement.
And that's 13.
Exactly so, my
Yeah.
Lord. And clause 13 begins on page 45.
Yeah.
There are 4 stages. 4 stages of building, A, B, C, and D. We're here concerned with stages C and D. Jupiter 2 and Hemisphere are stage D buildings because they are governed by 13.8. They're stage D because, and just for your Lordship's note, the definitions of stage A, B, C, and D buildings are at 81, page 81 and following. But they're stage D because a grant funding award has been signed. And indeed, for completeness, I can show you page 118, part F of the schedule to the self-remediation terms. There are stage D fund buildings. And over the page on 119, there are Hemisphere and Jupiter 2, the second and third entries. So they are stage D buildings for the purposes of this contract, but everything is subject to the side letter, which your Lordship has seen. Clause 13 deals with...
sorry to interrupt. This document, this contract, is the one you're engaged in litigation about in the TCC, is that right?
Yes, I understand that a claim has been brought by Redrow in the TCC for declaration under this contract.
Right, okay, thank you.
And then at clauses 13.17 and following, provision is made for challenges to reimbursement amounts. 13.17, there is an obligation on the department, together with any demand for payment, to provide the developer with certain materials. And no amounts are payable unless and until those have been given. And 13.18, the developer has a contractual right of objection to any reimbursement claim on specified grounds, including that it was manifestly ineligible for funding according to the rules of the relevant fund. There are further provisions which then apply.
And are there any rules of the relevant fund other than the guidance we've looked at?
No. Certainly not. I can only speak in relation to the BSF. There are no fund rules beyond those set out in the guidance. Clauses 13.19 and following, further provision is made to legislate for the scenario in which a developer does wish to object to a reimbursement claim. There is then here in the contract a contractual commitment to pay sums set out in the reimbursement statement unless one of those 3 grounds applies and unless the developer gives notice. The parties have catered by their contract for the possibility that funds may be paid out in breach of fund rules, and that the developer may wish to object to reimbursement on that ground. And they have agreed a mechanism to deal with that kind of dispute.
How does that work with the side letter? Because the side letter says it doesn't come into effect until these proceedings have been dealt with. So to rely on something that's in the deed to defeat the claim becomes sort of slightly circular.
I accept that this doesn't come into effect at the moment because of the effect of the side letter. Right. But the point which it leads up to, I hope, is this, that the potential interest of a developer in Redrow's position in a funding decision under the BSF is a financial interest. A funding decision may result indirectly in a financial liability under the contract. But that's a liability which can only arise in private law. And there's an agreed contractual mechanism for dealing with disputes about such a liability, for dealing with challenges to reimbursement claims. My learned friend referred by reference to a passage of Smith to Lord Hope's dictum that a claimant doesn't need a private interest if they can show that they are claiming judicial review in the public interest. But that's not what Redrow is claiming to do. It says, I stand to be adversely affected by this decision. And because that private interest is engaged, I have standing. That won't do for the purposes of the standing rule in section 31 of the Senior Courts Act, in my respectful submission. The standing rule requires a sufficient interest in the matters to which the application relates. And here, the application for judicial review relates to the decision to enter into the grant funding agreement. The interest of Redrow is not in that funding decision. It's in any potential claim for reimbursement which the department may subsequently make. And that interest that Redrow has is a private law interest regulated by the contract. So I say there's no relevant interest at all for the purposes of the standing test. If I'm wrong about that, I say that the interest isn't sufficient to justify the grant of permission to claim judicial review when any dispute about a reimbursement claim can, in due course, be determined under the contract. So we have looked at it through the prism of standing. That's the only point we've taken in this regard. One could equally look at it through the lens of the existence of an alternative remedy. But ultimately, disputes about whether reimbursement claims should be allowed are for determination as a matter of private law under the contract.
But if we wind back to when the decision was taken, there was no private law mechanism.
Yes, I accept that, Lord.
So Redrow see a decision which could may have the effect of making them £30 million down. Are they not entitled to challenge that, given that there is no contract? So the mechanisms in 1318 aren't available to them.
Well, the position in my submission is for your lordships to determine now, does Redrow, at the moment the court is deciding whether or not permission to claim judicial review should be granted, does Redrow have a sufficient interest?
Well, that's why I asked you about that provision in the side letter, because both sides seem, for perfectly understandable reasons, to have been very careful to exclude the judicial review from it. So are we entitled to take it into account or not?
Well, my submission is that Redrow's only interest can be a private law interest under the contract.
And not a public law interest?
Yes, my lord. And of course, Redrow had disclaimed repeatedly any liability under the pledge or any liability on any other basis to make reimbursement.
Yes, I wanted to ask you about that, because that's your argument that if they'd agreed under the pledge to make payment, they could challenge the decision. Which seemed counterintuitive to me. You could only challenge the decision if you'd agreed to it. Doesn't seem right.
Well, the oddity in my submission arises from the position which Redrow itself is taking, because its own position is we have no obligation at all in respect of these two properties, because there's an insurance policy which will pay out.
Yeah.
But that being the nature of their complaint, it follows from their own position that they can't have any interest in the department's decision.
But that's only one slightly tendentious way of putting it. Because as soon as one recognises that the insurance policy may not pay out for whatever reason, then they are back in the frame.
well, their own positions that are not in the frame at all.
I know their own position, but if your position is that they are in the frame, can you say they have no standing despite the fact you assert that they are in the frame? They may be wrong.
Well,
Singer's possibly wrong.
They will be in the frame once these proceedings are resolved, because then the contract will bite on Jupiter 2 and Hemisphere.
Yeah, but I may have completely misunderstood, but I thought you were saying they're in the frame, whatever. We can see that they're in the frame, or your position is that they're in the frame, whatever.
Well, I'm not asserting that the pledge has any binding contractual force.
No.
Redrow's own position is that it gives rise to no obligation on them.
What about the interest that through the insurance contract? Because the insurers were saying actually it's all Redrow's fault because they put this cladding up and they're liable for breach of warranties to us. I mean, doesn't that give them an interest in the decision making to initiate these and then claim?
It wouldn't be an interest engaged by the decision to grant funding, in my submission. They clearly have an interest in relation to these two buildings. Because they were the developer for them. But this point about standing, I should say, is likely to prove a one-off, because now the developer contract has been entered into.
Yeah, no,
So it's, if you like, a historic
I see
point.
that standing arises because it's effectively we're in the pledge, not the contract.
Yes.
You get that? Yeah.
And it is a position which the department has taken in response to Redrow saying, we're not responsible under the pledge.
Yeah.
And we say, simply, you can't at once deny responsibility, deny that you're on the hook in any way, and claim that you have a sufficient interest in the decision to throw a spanner in the works. That's all I wanted to say about standing.
Just before we leave that then, can I just ask you one question? It may be of no relevance at all, but just for my own note. In the pledge, at page 61, the supplemental bundle, there's a passage about claims. Do you have that? It says,
Yes.
and it says that the full form documentation will make clear that all civil claims, etc., etc., etc. Is there a part of the deed where that is replicated?
There is, my lord.
Don't, if you've got it to hand, that'd be brilliant. But don't. I'm sure you can supply it over the shorter German. If not, it's not a test for how quickly you can find.
I'm grateful to your lordship. I know that there is one. I shall dig out the
Well,
reference.
then let's do that at 2. It's just I noticed because that was referred to in the documents, and I wondered, oh, has that come into the deed? And I've looked quickly at the deed. I couldn't see it, but I have not looked line by line. So fine. Okay, if you could just bear that in mind. Thank you.
That brings me to my third head of submissions, which concern the lead up to the decision and the decision's fairness in that context.
Yeah.
Your lordships, I think, have the point that the decision of the 26th of August 2022 followed several months of correspondence between the department and Redrow. And it's necessary to consider Redrow's complaints of unfairness in the context of that stream of communications. I don't intend, unless your lordships would like me to go through every every salvo.
I think we're all very grateful for that. We have been through the exchanges, even following them backwards, because of the way in which they're set out. So any highlights that you want to make, fine, but we don't need a trawl.
I'm grateful for that indication. The claimants and the first interested party have also produced very helpful chronologies, which are at pages 63 and 210 of the full bundle. May I then just flag three of the key letters from the department. The first is at page 82 of the supplemental bundle. So page 82 is an email of the 8th of June.
Yeah.
Responding to a request for clarification of which projects continue to be progressed by the BSF. And in relation to Jupiter 2 and Hemisphere, the department's position is set out very clearly on page 83.
Yeah.
The objective remains that works continue at pace and without disruption. Noting the prospects of successful insurance claims on these projects, we will continue to run the projects through the BSF, and we will expect Redrow to reimburse the department for the costs of BSF eligible works, with any insurance proceeds to be netted off from Redrow's reimbursement. That is quite clear. Then on page 80, this forms part of an email from James Hewlett of the department on the 4th of July 2022 in response to a further email from Redrow about insurance. The department say, this under the heading Hemisphere and Jupiter 2, we have noted your comments on the insurance claims for these buildings. Having assessed the available evidence, the department and its delivery partner, Homes England, do not agree that funding from insurance claims is available to fund the remediation of these buildings and allow works to start on their expected start dates. They have considered the essential point which my own friend was making this morning. Funds are available from an insurance company, and they reject that. Given that you have indicated that Redrow are unwilling to take on the work for these buildings, we will be continuing with the BSF awards as part of Redrow's commitments that we expect you to reimburse the department. So it's clear there that part of the reason for proposing to carry on with the awards is that Redrow are unwilling to take on the works. There was then a meeting, or rather I think a call, it was going to be a meeting, but it turned out to be a call on the 14th of July, after which Redrow sought an update from the department, and the department responded on the 11th of August. You see that at page 143. The email at the bottom of the page on the 4th of August is Redrow seeking an update. And then Mr. Hewlett of the department responds.
143, did you say?
Yes, my lord.
Yeah, thanks.
Email of the 11th of August.
Yeah.
We've been considering the position for these two buildings and investigating further the evidence with you supplied on the warranties. These are the insurance-backed Zurich warranties. With regard to the warranties, we understand that in neither case is sufficient funding available, which would allow the buildings to meet their anticipated start dates, as below. Having spoken to the management companies and the leaseholders, we're confident that the department would be able to recover proceeds from successful Zurich warranty claims should the department continue with the BSF grant. So the department has specifically addressed the question, do we think we'll be able to get the insurance monies if we grant BSF funding? And then this paragraph, I wanted to ask you to confirm your approach to the projects. Our understanding from the call on the 14th of July is that in the event that the department decided not to proceed with our funding award, Redrow would be willing to take over responsibility for carrying out all life-critical fire safety works. And then the department set out the relevant start dates. So it's clear that on the 14th of July, there had at least been exploration of the possibility of Redrow taking over the work. The email concludes, I'd be grateful if you would be able to confirm your position with respect to the above in writing as soon as possible. And the next thing we had from Redrow is McFarlane's letter saying, we will not be reimbursing you and we will not be carrying out the works. It's against that background that on the 26th of August, the department replied saying, we note your letter, we're going to enter into the grant funding agreements. There was no unfairness to Redrow at all in how the department dealt with it. I do say that it's trite that there's no general public law duty to consult, no general public law duty to give reasons. I do say that the principle of fairness did not give rise to such duties in this case because it wasn't Redrow's application. But in any event, the correspondence shows that the department maintained an open channel of communication with Redrow. It took account of the information which Redrow supplied. It in particular took into account the insurance position, the Zurich warranties that we saw mentioned on page 143. But funding was necessary in order to allow work to commence on the existing project start dates. That's why the department decided to enter into the GFAs. That was perfectly clear to Redrow from the decision read in the context of the correspondence that had preceded it, and that is enough. I don't propose to address your lordships on the later GLD response to the pre-action letter, save to say that the explanation of the reasons that was there set out is entirely consistent with the documentary record that your lordships have seen. And I should say that I don't accept for a moment the characterisation that my learned friend gave that letter of blanket stonewalling. That's not what GLD on the department's behalf did in that response.
You say, I think it's paragraph 25 of the response letter, you say, well, actually, that is doing no more than summarising the points that have been in the correspondence that we've been through. Because I think Mr. Singer's point was, well, there's no evidential basis for any of this. And you say, well, you look at the correspondence and it's a summary of the points that have been made in the correspondence.
I wouldn't want to say, my lord, that it's a mere summary of the correspondence and that that wasn't an explanation that had no regard to instructions as the actual thought process of the department.
No, I didn't. No, that wasn't I'm just saying you're addressing the point that in some way this is all ex post facto. You say no, you look at the correspondence and the points are there.
Yes, absolutely. And of course, but in the spirit of responsible and reasonable pre-action correspondence, it's important that a respondent should clarify its reasoning in response to an allegation of insufficient reasons, so that, for example, Redrow could have brought an irrationality challenge had it thought there was a proper basis to do so.
I think originally this was a rationality challenge, but it isn't now.
I think that's right.
Yeah.
So, my lords, unless I can assist you further on any of those points, I shall hand over to Miss Wakeman.
So, let me just make sure. No, thank you very much. Yes, Miss Wakeman, you're dealing with delay.
Yes.
Thank you very much.
My lords, in addition or in the alternative to the reasons Mr. Justice Garnham gave, the respondent invites the court to uphold his decision to refuse permission on the basis that the appellants failed to file their claim for judicial review promptly. And that's point B of the respondent's notice.
Yeah.
Acting promptly is, of course, a freestanding condition for obtaining permission for judicial review under CPR Part 54 and Section 31 of the Senior Courts Act. And here we say there was a clear failure to act promptly, which, with all respect to Mr. Justice Eyre, in itself justifies the refusal of permission.
Yeah.
And I pause there just to address the overarching point made by the appellant in their submissions. It's said on behalf of the appellants that since delay is a matter of discretion, it shouldn't be overturned by an appeal court without being obviously wrong. But the issue is that Garnham J didn't deal with the issue of delay in his judgment. It was only Mr. Justice Eyre that did, and of course this appeal is against the decision of Mr. Justice Garnham rather than Mr. Justice Eyre. So in my submission there's no need here to show that it was obviously wrong, and the court is entitled to find that the delay is a reason to uphold Mr. Justice Garnham's decision, in addition or an alternative to the reasons that he gave. In my submissions, first I'll set out very briefly the key dates relevant to the issue of delay. Secondly, I will address the justification raised by Redrow for its delay. And finally, I'll outline the prejudice that will be caused if this claim were allowed to proceed, notwithstanding the lack of promptness. Turning first to dates. The first date of relevance, I say, is back in January 2021, and that's the date on which Redrow first became aware of the need for the remediation of fire safety defects at Jupiter 2 and Redrow, and wrote a letter to Jupiter 2 asking the leaseholders to confirm whether applications had been made to the BSF or whether insurance claims made. I don't invite you to turn that up, but for your note, that's the supplementary bundle, page 285.
285, did you say?
Yes.
Thank you.
Correspondence between Redrow and the department, specifically relating to the buildings here, Hemisphere and Jupiter 2, then began on the 25th of May 2022, when Redrow wrote to the department to state that it would not reimburse the BSF in respect of those buildings. That's supplementary bundle, page 77. The court's already indicated great familiarity with the correspondence, and like Mr. Richards, I won't take you through that.
We've indicated familiarity. I don't think we've gone as far as to say great familiarity, but don't take us to the correspondence, just give us the references.
Thank you, my lord. As the court will be aware, there was essentially a back and forth between the department and Redrow from May 2022 until August 2022, whereby in essence the department was asking Redrow to confirm it would reimburse the BSF, and Redrow did not accept the department's proposal. And as we know, this culminated in a letter from Redrow to the department on the 22nd of August, McFarlane's letter, whereby Redrow indicated it was not willing to carry out or fund the life-critical remediation works in respect of the developments. Supplementary bundle, page 175.
Yeah.
Following this letter, the BSF funding decision with which these proceedings are concerned was communicated on the 26th of August 2022 to the appellant's legal representatives. That's on page 160 of the core bundle. If I could just invite the court, I know we've looked at it today already, but to turn it up. If you have tabs, it's tab 17.
Yeah.
Two paragraphs. Turning to the second one first. That's, of course, the part where the decision is communicated. The department states it's decided to enter into the grant funding agreements, and that the department expects Redrow to reimburse the department for all funds paid out under the terms of the GFA. And then the first paragraph, there it's stated, "Thank you for your letter of 22nd of August 2022. The department has noted the contents and will respond substantively shortly." I'll come to this part later, as Redrow relies on those two sentences partially in justifying the delay in bringing these proceedings. So by the time we get to the department's decision on the 26th of August 2022, I say it's highly relevant to the issue of delay that the appellants were...
Sorry, I thought we were looking at the key dates. Have we stopped the key dates now?
Yes, I've finished the key
Right,
dates.
so your second heading was justification. Or do you have a submission about those dates?
This is submission drawing, essentially it's drawing the dates together to say
Right.
the knowledge that the appellants had at the time of the decision, which is the 26th of August 2022.
Yeah.
And I say it's highly relevant to the issue of delay that the appellants were aware of the following 4 key facts. 1, Redrow knew that the residents of Jupiter 2 and Hemisphere were living in buildings with life-critical fire risks caused by cladding, and had been aware of that fact for almost 2 years.
Yeah.
Secondly, Redrow knew that the estimated start dates for the work of the development was the 22nd of September 2022 and the 17th of October 2022 for Jupiter 2 and Hemisphere respectively. And that's supplementary bundle page 143.
Yeah.
Thirdly, Redrow knew, because the department had expressly indicated this in previous correspondence, that in relation to Jupiter 2 and Hemisphere, there was a need for the remediation works to continue at pace and without disruption. That was communicated in an email from the department to Redrow.
We've just seen that in Mr. Richards' submissions.
It's page 97, supplementary bundle. That was back in June 2022. Fourthly, and crucially, Redrow was of course aware of the contents of the BSF guidance, and I won't ask my lords to turn it up, but to give you the page references, and the 2 parts I say are of particular relevance. It's the parts Mr. Richards, Casey, took you to. So page 30, one of the stated priorities of the BSF was to, quote, drive the pace of remediation, unquote, of cladding, and to ensure that, quote, life safety fire risks associated with cladding are addressed as quickly as possible to ensure that residents are safe and feel safe in their homes. And secondly, page 27, supplementary bundle, the first stated objective of the BSF is, of course, that the historical life safety risks associated with cladding on high-rise buildings is addressed quickly and proportionately. So I say, drawing together those 4 key pieces of knowledge, in those particular circumstances, it was incumbent on the appellants to act with particular speed in challenging the decision of the 26th of August, if they intended to do so. Notwithstanding that the appellants were aware of these considerations and the very clear emphasis on pace of remediation, and the fact that they had everything they needed to initiate their challenge in August 2022, the appellants delayed until the 19th of October 2022 before sending their pre-action protocol letter, which is at page 193 of the supplementary bundle.
Can I just ask you about that last submission where you said they had everything they needed to respond to bring the proceedings? They hadn't got any letter from you at that stage. So normally you would then expect the defendants to jump up and say this is premature because we haven't even responded to them.
My lord, it's right that they had not received any response from the department. The reason I say that they had everything they needed to initiate their challenge is because they, of course, went on to be able to initiate their challenge through the pre-action letter without a response. And
That's unfair. Government departments can't take the delay point on the one hand and then, on the other hand, rely on the fact that they haven't provided reasons for saying, well, look, the reasons didn't matter because in the end they made a claim. I mean, it's got to be a level playing field.
My lord, I note the point. The one point I would draw your attention to, which is from the witness statement of Mr. Anthony Parkins. This is supplementary bundle, page 234. I'm taking this from paragraph 42.
Supplementary bundle 234.
Yes.
Yeah.
It's just a short point, which is that Redrow didn't chase any response from the department. It's simply that they sent a letter of the 22nd of August, and the next piece of correspondence that came to the department was the pre-action letter.
Sorry, which bit are you looking at? Which
Paragraph
paragraph?
42.
Paragraph 42.
It's not explicitly said, but he lists the correspondence that was sent.
Yeah. And then paragraph 43, as I've stated above, the delay in bringing the claim after the decision is because the claimants were waiting for the substantive response.
Yes.
So that's his evidence.
There's no getting away from the fact that Redrow say they were waiting for the substantive response.
Yeah.
The points I'd make in response to that, and I think this is coming onto the justification section of my submissions, is firstly I do say that they were able to issue the pre-action letter with what they had in August, and given the extensive correspondence that had taken place prior to that date.
Well, they waited 6 weeks from
It was almost 2 months before.
26th of October to the 26th of August to the 19th of October.
Yes, so I'd point to the fact it was almost 2 months after the decision, but also it was crucially 1 month after the remediation work at Jupiter 2 had already in fact begun. So whilst I note my Lord's valid concerns about the fact that the department didn't follow up as had been indicated in the letter, I would say that the very particular circumstance of the case, with the start date of the works very fast approaching, was one which warranted proactivity from the appellants to make their claim if they were going to do so, and it wasn't reasonable, I say, for them to sit back and do nothing whilst awaiting.
Are you taking a point that the suggestion there would be a more substantive letter came in the first paragraph and not the second paragraph? You're not suggesting that the statement that a bit longer letter would come didn't relate to the reasons for the decision?
I'm not wishing to go behind the text of the letter and make submissions about that.
So, how long can a person in Redrow's position rely upon an assurance from a government department that they're going to send a full letter?
Certainly, my Lords, I would have expected Redrow to have sent further correspondence in advance of the start date of the works, which they were obviously on notice of, and given the fact that they knew of the very urgent and pressing need to allow this construction work to begin.
So the mast that's pinned to is before start date.
That's one of the masts, yes.
That's the mast you're pinning.
In terms then of the prejudice, in my submission, there would be clear prejudice here to the management companies and other third parties, including contractors, leaseholders and residents, if this challenge were permitted to be advanced belatedly. And I make 3 points on that. First, the decision was intended to be, and was in fact swiftly acted upon, by the interested parties and their contractors, given the life, safety, fire risks that had been identified as requiring remediation.
But there's no evidence, sorry to interrupt you, but there's no evidence that if the challenge had been before the first start date, the works wouldn't have carried on.
No, I don't suggest that. I say that's one of the factors in why there would be prejudice
No,
caused.
but let's assume for a moment that they had written the week before the works had started, so in accordance with your mask. And let's assume for a moment that normal timings, prompt timings follow on from that. They're not going to stop the work. There's no way that the decision is going to be voluntarily removed. So at the moment, your assertions of prejudice sound more like a lawyer's construct than real to me.
I think the difficulty is looking back now, it's virtually impossible to say what might have happened.
Quite. So it's virtually my suggestion would be it's impossible to say you've suffered prejudice.
Well, it's the prejudice that will be suffered were this claim now to be allowed to proceed, given the facts.
Well, I follow that. That may be a slightly different point. Anyway, I see the time. So engrossed have we been in the arguments about delay that I've let the time slip on. So I'm very sorry. We'll come back at 2:05. You can finish and we'll hear from Mr. Barker. Thank you very much.
Excuse me, are you going to lock the court?